much to lay out here.
It is absolutely fascinating because what Judge Breyer did, does the name ring a bell? Breyer?
Yes.
He is the younger brother of retired Supreme Court Justice Stephen Breyer. What Judge Breyer did was the first time in American history that a federal district court judge has enjoined the president's use of the military. He didn't rule on the Marines. He said, under the Constitution, the president can only federalize the National Guard in 3 circumstances. With the governor's consent, doesn't have it. If there's an invasion, there's not an invasion. If there's a rebellion, which is an effort to take over the government by statutory definition, it's not a rebellion. Therefore, this is unconstitutional and illegal. He then said, I'm not going to tell anybody to move the troops around. There are people that could die out there. I'm just transferring command of the troops from the president, as you said in the intro, Mark, back to Governor Newsom, where under the state constitution and the federal constitution, they reside. Then the government appealed. Then the Ninth Circuit Court of Appeals, as you said, the most liberal in the country, said, hold up for 4 days. We want briefs, and we'll have oral argument on Tuesday. That's where we are now.
So,
got it. Okay.
But according to Judge Breyer, not Justice Breyer,
right,
that means John F. Kennedy, Dwight D. Eisenhower, and Lyndon Baines Johnson were illegally taking over control when they used the exact same power to overturn a Democrat governor who would not follow the law.
The short answer to what you said is yes. The longer answer is he didn't address that in his opinion.
I didn't think he would.
No, he is not addressing precedent where this happened before. He addressed the statute, the Posse Comitatus Act, and he addressed the Constitution. So here's the uniqueness of what he ruled. When the president federalizes the National Guard, they become federal troops. Under the 1878 law, federal troops cannot engage in law enforcement. They can't detain people. They can't arrest people. They can't direct traffic. If they were under the command of the governor, same human beings, they can engage in law enforcement. They can direct traffic. They can detain people. They can arrest people. Therefore, it is a more efficient use. Now, the court just shouldn't be ruling on efficiency. It should just be ruling on the law and the Constitution. It is a more efficient use of these human beings. There are now 7,000 of them, National Guard troops, if they're under the command of the governor.
Got it. So I would think it's a similar process with the Marines. I mean, what about them? Was their issuance of their, deployment in L.A. also discussed?
You know, he delayed until noon today, California time, 3 o'clock our time, a ruling on the Marines. I suggest to you he's probably not going to rule on the Marines and just let the appeals court take care of everything on Tuesday. It was a profound repudiation of the president. It was a profound lesson in, not personal repudiation, of course, profound lesson in constitutional law. And he wrote 36 pages with 100 footnotes in about 2 hours.
Boy, he likes to write.
And he's 82 years old.
Now,
God bless him.
The one thing about the difference about the Marines, though, is the Marines have been sent there to protect federal infrastructure and federal buildings, much like they would be to protect a U.S. embassy overseas.
If that is all they do, there is no constitutional impediment and there's no legal impediment. They're not engaging in law enforcement. They are protecting federal assets, which presidents have used them to do all the time. And as you said, every embassy in the world has Marines there, which is U.S. property, has Marines there to protect the asset.
So it's going to be interesting. What do you think?
I'm going to read the briefs over the weekend, and I'll give you my opinion on Monday morning, and then the court will decide on Tuesday.
If the court decides against the president, then, so just so we know, you and I talked about this, it looks like Justice Kagan would be the Supreme Court justice who would immediately get appealed to.
Correct.
And she has to read the room.
Correct. So Justice Kagan hears emergency appeals from the Ninth Circuit, which is the 15 westernmost states of the United States. She would, as Mark said, read the room, decide which way her colleagues are likely to go. If she enjoins the Ninth Circuit, hold off, or if she says, we're not going to touch your decision, but we'll rule. Now, ruling in June, the Supreme Court's pulling its hair out. Lawyers, even Supreme Court justices, are notorious for doing their work the last minute. What do you think they're doing now? They have 20 opinions that have to come out in the next 2.5 weeks. The last thing they want is a hot potato like this on their table. So guess what? They're going to have that hot potato on Wednesday.
Information. truth is freedom. Is Newsmax. It's real news for real people.